Good morning, Kenyans. Good morning, friends. Good morning, learned friends. When we stood outside the lawns of Gitanga House here about a month ago and notified Kenyans that we had petitioned the Chief Justice of the Republic of Kenya to advise the President of the Republic of Kenya, as the two are required under Article 261(7) of the Constitution to dissolve Parliament, I was singled out for criticism. It was said, what is the standing of the Law Society on this matter? Who is the client of Havi in this issue? What is the moral obligation of the Law Society to demand that we have implementation of the 2/3 gender rule? Yet the Council of the Law Society of Kenya is not 2/3 gender rule compliant. Perhaps there is merit in that assertion, or there may be no merit in that assertion. Article 81 of the Constitution of Kenya requires that not more than 2/3 of elective members of any public bodies should be of the same gender. Is the Law Society of Kenya a public body? I think the Law Society of Kenya is a public body. I also think the Law Society of Kenya is an arm of government. I dare say it should be the fourth arm of government. And for that reason, I want to implore the Attorney General and our members of Parliament to ensure that the Law Society occupies its place as the fourth arm of government. And this should be done in two ways. First, the budgetary allocation of the nation must cater the Law Society of Kenya, because the Law Society of Kenya plays a fundamental role in upholding the rule of law and the administration of justice. The Law Society of Kenya participates in almost 80% of appointments to public offices in Kenya. And if that be the case, then I will undertake to ensure that the 2/3 gender rule is implemented in the Law Society. But I don't think there is any cause of alarm insofar as the Law Society of Kenya is concerned. Perhaps here at the Law Society of Kenya, we have surpassed the 2/3 gender rule in favor of the female gender. And it is for that reason, therefore, that the need to implement the 2/3 gender rule is more urgent now than before. Because the 2/3 gender rule is not specific to women. The 2/3 gender rule is intended to ensure equality and equity of representation. Because, as George said, this is the first ever conference of the Law Society of Kenya on the 2/3 gender rule. Perhaps the next conference will be towards ensuring affirmative action to balance and maintain an equilibrium 10 years from now, when the female gender will have occupied more offices in Kenya. And that is good. But what is fundamental is to implement the Constitution. In December 2012, the Supreme Court made two decisions. There was a majority decision and there was a dissenting decision. The dissenting decision by former Chief Justice Dr. Willy Mutunga was to the effect that the 2/3 gender rule must be implemented here and now. Why did he say that? He said so because he feared that if that was not the case then the parliament that will assume office as the first parliament post promulgation of the Constitution suffered being in office unconstitutionally. The majority view was that the implementation should target 5 years from the date of promulgation of the Constitution, and that will have been the 27th of August 2015. I think the entire court was right. because come August 2015, the two-third gender rule had not been implemented. A month before, the High Court had been approached to consider this issue. And the High Court made an order that the National Assembly, Senate, and the Attorney General must take steps to ensure compliance. There was no compliance. By the time we neared the election of 2017, again, the two-third gender rule had not been implemented. This matter went back to court, and the court gave the last opportunity to the Parliament and the Attorney General to ensure that this fundamental aspect of the Constitution is implemented. And the High Court ordered that in the event that Parliament and the Attorney General will not have implemented the two-third gender rule, then the petitioners then before the court or anybody else will be at liberty to petition the Chief Justice of the Republic of Kenya to act as is required under Article 261 of the Constitution and advise the President of the Republic of Kenya to dissolve Parliament. As you are all aware, Parliament went to the Court of Appeal and challenged the decision of the High Court. What did the Court of Appeal say? The Court of Appeal said that Parliament has been reluctant to perform its duty. And this reluctance has been punctuated by excuses of lack of quorum. And the Court of Appeal said, it is for that reason, therefore, that the people of Kenya deemed it fit to have an inbuilt mechanism within the Constitution under Article 261(7), which will enable the people assert their authority and the will as the sovereign. The Court of Appeal therefore dismissed the appeal by Parliament. Several petitions were lodged with the Chief Justice of the Republic of Kenya, asking him to perform his duty and advise the President of the Republic of Kenya to dissolve Parliament. The Chief Justice was of the view that efforts had been undertaken then by the National Assembly and the Senate, and he requested that they be given time to comply. 2 weeks ago, the Chief Justice of the Republic of Kenya summoned a total of 8 petitioners who had petitioned him to advise the President of the Republic of Kenya to dissolve Parliament. And the Chief Justice of the Republic of Kenya confirmed, as a matter of fact, that the time that Parliament and the Attorney General had requested for had lapsed. It was also evident that nothing had been done by Parliament and the Attorney General to ensure that the two-third gender rule had been complied with. For that reason, therefore, the Chief Justice of the Republic of Kenya acknowledged the fact that the process towards dissolution of Parliament had to commence. Friends, it is on that backdrop that we have gathered here today to deliberate on this important topic. And this topic is beneficial to all of us because there are those who say there is no need for the two-third gender rule. What is their justification? They say that women must battle with men on the ballot and determine whether they are suitable to lead as a result of a popular vote. Why must this statement be entertained? Who are these women you are referring to? Are these not your grandmothers? Are these not your mothers? Are these not your wives? Are these not us? Is that really what you want for them? Remember what Dr. William Mutunga said in December 2012. We must protect the position of the women of Kenya here and now. Parliament has been given the responsibility of legislating on our behalf. They derive authority from the people. The executive has been given authority to implement the laws of this country and to implement policy on behalf of the people of Kenya. The people of Kenya are you and I. If these two institutions have failed in their obligation, and that failure has been acknowledged by the judiciary, then we, the people of Kenya, must exercise our authority as given by the Constitution. May I therefore officially declare the Law Society Conference on the two-third gender rule open. The question as to whether there was need to have this requirement in the Constitution is no longer before the table. The question is, what will the Chief Justice, what will the President of the Republic of Kenya, what will be the role of the people of Kenya on this issue? Let us discuss, let us make resolutions, let us inform the course the country will take in the next few days, in the next few months, and for a long time to come after now. Thank you. Welcome.